On debate on the amendment, Senator Simons.
I rise today in support of Senator Clement's amendment to Bill C-5, an act to amend the Criminal Code and the Controlled Drugs and Substances Act. And I want to start this story with a trip I made alongside our colleague Senator Pate to the Edmonton Institution for Women, a federal prison that serves the Canadian prairies. When we visited there last August, the facility was full. Indeed, it was over capacity. And of the prisoners, we were told 70% were Indigenous, First Nations, Métis, or Inuit. This is one of the terrible injustices that Bill C-5 is designed to address. The bill removes mandatory minimum sentences for 20 criminal code offenses, returning to judges the discretion and responsibility to craft sentences that are appropriate for all the complicated circumstances of a particular crime. Mandatory minimum sentences rob judges of their authority and autonomy, and they rob convicted criminals of the chance to receive an apt and nuanced sentence, one that takes into consideration all their complicated social circumstances and personal histories. The hope was that by eliminating this constellation of mandatory minimum sentences, we would not only achieve greater justice for Indigenous, Black, queer, and other marginalized defendants, but that we could make the justice system more just for everyone, reduce pressures on our courts and prisons, and return to judges the respect and independence they require. C-5 goes further. It would encourage police to consider diverting people, particularly those arrested for relatively minor drug offenses, away from the criminal justice system and towards programs that treat drug addiction as a medical and psychiatric condition. There are also important changes to the use of the conditional sentence, so more defendants would be considered eligible to serve their sentences, carefully monitored and restricted in their homes. And I have certainly heard from criminal trial lawyers of their great impatience for this bill to be passed quickly, so present and future clients can benefit, especially in the light of the recent Supreme Court decision in Sharma, which demonstrated the limitations of relying on the courts to expand conditional sentences as an option. And yet, I feel I must speak in support of this amendment, because if we do not act now, we may miss a vital opportunity to address a larger and deeper problem. As Senator Clement noted, Bill C-5 removes some mandatory minimum sentences, but leaves many others intact, including sentences that have already been found unconstitutional by various superior courts across the country. That's not only absurd on its face, it sets up a bizarre patchwork of sentencing protocols across the country. Commit a particular crime in one province, and you get a completely different sentence than if you commit exactly the same crime in another. That makes a mockery of our criminal justice system and of the human rights of Canadians. Canadians are entitled to equal treatment under the law, no matter what province they call home. In a federation such as ours, a federal criminal code must surely be applied equally, from British Columbia to Newfoundland. C-5 is also silent on one of the greatest areas of sentencing injustice, the crime of murder. Now, you may say, well, of course it does, Senator Simons. Murder is the worst of crimes. Of course it demands a mandatory minimum sentence. Who could question that? But we need to recognize a real risk that men and women who are facing the mandatory minimum sentence for murder, that's life in prison with no chance of parole for 10 years for second-degree murder and no chance of parole for 25 years for first-degree murder, will not dare take the risk of a trial, but will instead plead guilty to manslaughter to get a shorter sentence in the sort of scenario that Senator Cotter described so well. Even if they have a legitimate defense at trial, many will take the plea deal, either because they can't afford to mount a vigorous and well-funded defense, or because they just don't want to gamble on the verdict. Which takes me back to my visit to the Edmonton Institution for Women. While I was there with Senator Pate, we met a young Indigenous woman I'll call SB. She wore a large and noticeable crucifix and spoke in very emotional tones about her love for Jesus. Later, she pulled me aside to ask if I could help her with her case. She had just been convicted of manslaughter. But she told me earnestly she had been possessed by demons when she committed the crime. There was something about her vulnerability and her obvious psychological distress that moved me and made me curious, so I researched her case. It wasn't easy. She had been arrested in Winnipeg in 2020 and charged with the second-degree murder of a man with whom she'd been living. While there were a couple of short news blotters in the media from the time of her arrest, there was absolutely no coverage of the outcome of the case. So I contacted the prosecutor. I wrote to the judge, and after several months, I finally got enough court documents to try to piece the tale together. Both SB and the victim were meth addicts who'd been squatting together in a vacant house in Winnipeg. Neighbors became concerned about what was going on in the house and called police. When police arrived, they found a man's body, his head bashed in. The body was seriously decomposed, and the medical examiner could not say how long the man had been dead, estimating it might have been anywhere between 2 days and 8 days. The medical examiner determined the man had died of blunt force trauma, but the autopsy couldn't say what weapon was used, and I found nothing in the public court record to indicate that any weapon was ever found. Police quickly arrested one of the dead man's known male associates. In court documents, the man was described as a, quote, unsavory witness, based on his criminal record, and that he provided a statement to police only after he had been arrested for the murder himself, end quote. This, quote, unsavory witness told police that it was SB who had beaten the man to death with an axe handle, and that he himself had walked into the room and seen her doing it. Now, to judge by the court records I had the chance to review, the police never found any forensic evidence linking Ms. B to the crime. There's no mention in the files of blood spatter or fingerprints on a murder weapon. No mention of any murder weapon at all. Police couldn't even reliably place the woman in the house at the time of the killing because they had no independent forensic evidence to determine the date or time of death. There's also no indication of any motive to explain why SB might have killed her companion. The key evidence was the personal testimony of the original suspect arrested for the crime. That and SB's own extremely hazy memory. She told the court that she believed she had killed her companion, but that she had no clear memory of doing so and no reason or explanation for why she might have wanted to kill him. Let me quote from her evidence. That day the occurrence was happening, I can't even explain how to start on what happened because I have a little recollection of what had taken place that night, she told the court. All I know is that it was an unnatural occurrence, and I'm so sorry. And not ever in my life I thought I could do such a heinous act, and I just asked forgiveness from all sides, from my family, from his, especially his family. She had a poor, transient, and traumatic childhood filled with sexual and physical violence. Indeed, according to the pre-sentencing report, she described being abused by 13 different family members as a child. In an affidavit, she said she began drinking at 15 and became addicted to crystal meth at 18. She said she'd gotten off meth successfully when she became pregnant with her first child and stayed off the drug for 14 years. But she fell back into addiction in 2019 and had been living homeless on the streets of Winnipeg for 5 months before her arrest. She's now the mother of 6 children, and by the time of that arrest, she had already lost custody of all of them. Now, SB did have a criminal record with 19 offenses, which sounds pretty dire, except that 14 of those offenses were for things like failure to appear in court or failure to meet her curfew. The longest she had ever spent in prison at one time was 30 days. Nor did she have a history of serious violence. In fact, prior to her arrest in this case, she had only one minor assault charge in 2017 for which she'd received a conditional discharge. Now, you could imagine that this woman might well have been able to fight her second-degree murder charge at trial. You might suppose, for example, that her lawyer could have argued that she was not criminally responsible because she was suffering from a mental disorder that rendered her incapable of appreciating the nature and quality of her actions or of knowing they were wrong, especially in light of the young woman's avowed belief that she was possessed by demons or in a trance. You might imagine that a lawyer could have argued that SB was in the grips of drug-induced psychosis or self-induced extreme intoxication, especially since the young woman was sentenced before we rushed to pass, without due consideration, I might say, Bill C-28 last June. You might presume it could have been a viable legal strategy simply to demand that the Crown prove beyond a reasonable doubt that she'd actually committed the crime, given the paucity of physical evidence against her. And indeed, in June of 2021, after the preliminary hearing, the Crown actually applied to stay the proceedings in the case, stating that it had determined there was no reasonable likelihood of conviction. And yet, in January of 2022, the woman's lawyer wrote to the court that her client would be accepting a guilty plea. After all, a second-degree murder charge comes with a mandatory life sentence, with not even a chance of parole for 10 years. And by pleading guilty to manslaughter, SB received a sentence of 8 years, less credit for time served in custody, leaving her with a little more than 4 years left on her sentence. Now, this may not be the intent, but our mandatory minimum sentencing regime is positively set up to invite such guilty pleas, even when a defendant might well have a viable courtroom defense. And the poorest, most vulnerable, and most powerless defendants are the very ones most often pushed to take those plea deals because they have no capacity to fight back and, frankly, no hope. So let's just consider the outcome here. Because there was no trial, there was no news coverage, no public attention, no public questions about the facts, no public outrage. SB was sentenced quietly, invisibly, with no chance for people to hear her story or champion her cause, and then sent to serve her sentence thousands of kilometers from her family in an overcrowded prison filled with Indigenous women with stories nearly as bleak as hers. I decided to take the time to tell you the story of this one individual because it is so representative of the crisis within our criminal justice system and within, frankly, our society. The amendment I support today would not give judges unbridled license to ignore mandatory minimum sentences. It would simply give them the opportunity, in only the most extraordinary cases, in cases where the mandatory minimum sentence would be manifestly unfit, to suggest and then justify the substitution of a sentence apt for that particular defendant. It is, I accept, and for all the reasons that Senator Gold outlined, an imperfect solution, and perhaps an impolitic one. And I know that in the world of realpolitik, we run a real risk by pushing for this at third reading. But my friends, I had the privilege of serving as a member of the Standing Senate Committee on Legal and Constitutional Affairs during its study of C5. And I heard witness after witness come before us, academics, lawyers, advocacy groups, asking us all for just an amendment such as this one. I cannot in good conscience ignore their advice any more than I can ignore stories such as the one I've told you this evening. I hope you will think carefully when it comes time to vote. Thank you. Merci and hi-hi.